work in the US and to travel in and out of the US, but there are some caveats that you should be aware of. There are times when people with green cards are arrested, detained, and deported from the United States. So let's talk about how that could actually happen. One of the most common ways that immigration can target you is if you're using the green card as a glorified tourist visa. I see this frequently with elderly parents of US citizens. Oftentimes, they have a child who's a US citizen over the age of 21. The child petitions for the parents get a green card, permanent resident card, but the parents don't really want to live full-time in the United States. They want to spend like 6 months in the United States, 6 months outside of the United States, and just keep traveling like that back and forth. They want to have an easy way to enter the United States. So that's why they got the green card. I generally advise against this when I know it's the plan, because if you're not intending to permanently live inside the United States, you can technically be charged with abandoning your residency or not maintaining your immigrant intent and eventually losing your residency. A common way that this will happen, the most obvious way, is if you physically depart the United States with your green card for more than 1 year continuously. There's a presumption that you've abandoned your green card, so when you try to come back, there is a high chance that in the airport, the immigration officer will send you to a back room. It's called secondary inspection, and they will interview you. And the purpose of the interview is to determine whether you intended to spend more than 1 year continuously outside of the United States. If you ended up spending more than 1 year, I've had situations where people spent 3 or 4 years outside of the US because they had a health condition and it wasn't recommended that they get on an airplane during those 3 or 4 years. That might count as an exception because it was through no fault of your own that you weren't able to re-enter the US. You may have intended to return to the US within 1 year, but circumstances outside of your control prevented you from doing so. Ultimately, it's going to be up to the immigration officer, and if they decide that they think you abandoned your residency, they'll refer your case to an immigration judge. And then a judge will hold a full hearing to determine whether you intended to live outside of the US for more than 1 year continuously or not. Here's something to keep in mind. Oftentimes in these airports, the customs officers will say things like, here, just sign this form. It's a voluntary abandonment of residency form, Form I-407. And they'll say things like, you've spent 3 years outside of the US, just sign this form, redo the green card process, and it'll go a long way at the consulate when they see you voluntarily gave it up and now you're applying for it again. It'll be really easy for you to get your green card again. That is not necessarily true. I would go so far as to say never sign Form I-407 before you speak with an immigration attorney. I would straight up refuse to do so, no matter how nice and charming that customs officer in the airport might be. Have the case referred to an immigration judge and have it decided after you speak with your lawyer and have a hearing in front of the judge. Do not voluntarily sign Form I-407. There are even some instances where you can be detained in the airport, so arrested. And detained mean the same thing in this context. Arrested generally refers to criminal matters. Detained is civil matters, which includes immigration. Immigration is not inherently criminal. So if you're detained, again, don't sign Form I-407 until you speak with an immigration attorney. And I've even seen customs officers threaten to detain you if you fail to sign this form. But if you do sign the form, you're often put back on a repatriation flight back to your home country right away. So do not sign Form I-407 if you don't fully understand what you're doing and if you didn't speak with an immigration attorney first. After one of my clients becomes a permanent resident, and I have this conversation probably like 2 or 3 times a week, I give them a whole list of do's and don'ts of residency. Like, this is how you can travel internationally. You need to pay your tax returns. Do not register to vote. If you're arrested for any crime or charged with any crime, you need to tell me or an immigration attorney in addition to your criminal defense attorney. That last one is super important. As a permanent resident, you can still be deported from the United States for certain offenses. And these offenses may seem really small. I can't tell you how many times I've asked people about their criminal history, and they've said things like, I have no criminal history. And then when I dig deeper and I ask, have you ever had contact with the police? They say something like, yeah, I had a DUI like 7 years ago, but my criminal defense attorney told me that it's expunged and off my record, and I paid all the fees, and the criminal court said I'm good to go. It doesn't matter what the criminal court said. Every criminal charge, can have immigration consequences. And sometimes the criminal defense attorney you're working with doesn't understand the immigration consequences of criminal convictions. So it's important for a criminal defense attorney to either fully understand the consequences or for you to reach out to an immigration attorney so that the immigration attorney can work with your criminal defense attorney. I probably do this several times a year for people who get charged with convictions, and I end up doing some legal research and working with the criminal defense attorney to find a plea deal or a conviction that's not going to carry significant immigration consequences. Another way that a permanent resident, someone with a green card, can be targeted by immigration is when you're a conditional resident and you don't file your I-751, the petition to remove the conditions on your residency and become a full unrestricted resident, on time, or you fail to file it altogether. Something I see regularly is someone is a conditional resident, and by conditional resident, I mean you got your residency through marriage to a U.S. citizen, and on the date that you got your green card, you were a resident for less than 2 years. So generally, when this happens, your green card will have a 2-year expiration date on it. Before it expires, within 90 days of it expiring, you're supposed to file a form to remove the conditions on your residency, along with updated evidence of your marriage to show the government that this wasn't a fake marriage. So sometimes people just straight up don't file the form. They forget about it as soon as they become a permanent resident, even though USCIS usually sends you a reminder notice in the mail, or they accidentally file Form I-90 to renew their green card. Can't tell you how many times people with a 2-year green card have come up to me and said, I need to renew my green card. And I'm thinking, oh, we just need to file Form I-90 to renew the green card. And after I go through it with them, I realize they are a conditional resident. When they're saying renew green card, what they actually mean is remove the conditions so that they could get a 10-year unrestricted green card. If you don't apply to remove your conditions on time, you can actually lose your residency status and end up in deportation proceedings. And if you're subject to removal proceedings, you're subject to detention. And it's all going to come down to what are the government policies around detaining this class of immigrant. It's going to depend who the president is. Right now, if you're deportable, you may very well be detained, although it's yet to be seen whether the government is detaining non-criminals who are not a danger to the community or a flight risk. There will be more on that in the form of future YouTube videos once I have more information. But just know, at the